Ladies and gentlemen, the time is 8:25 a.m. The Subcommittee on Criminal Procedure will come to order and the clerk will call the roll.
Chair Harrison?
Here.
Representative Christina Morales?
Here.
Representative Schatzline?
Here.
Okay, quorum is present, and as a reminder, anybody present wishing to testify before the committee, please register the kiosks, which are located in the hallways behind the hearing rooms. If you require assistance registering or testifying, please contact the committee staff. And
If you want to put them.
yeah, I'm okay with that. Okay, okay, to accommodate everybody who wishes to testify today, we will go ahead and put a time limit of 3 minutes per witness during the public testimony period. Okay, and the chair is going to lay out, beginning, HB 3758, and this is a bill by Symphonia Thompson. However, she, due to logistics, is unable to be with us today, so she has asked me to lay out the bill, so I will administratively lay out the bill for you today. HB 3758, per the materials submitted by her office, seeks to modify several provisions within the state's civil asset forfeiture laws, and I will read to you a few of those. Her HB 3758 specifies what property is subject to forfeiture. It states that contraband is still subject to seizure, requires a conviction before forfeiture of property, requires that assets seized must be connected to the charged offense, protects Texans from having their low-value cars and pocket money forfeited, and protects innocent owners if their property is used for illegal activity against their will. So members, if you have any questions regarding Representative Thompson's bill, I am giving you the floor to ask them to me instead, and if not, I'm happy to transition to invited testimony. Any questions, members? All right. Oh, that's right. We're going to public testimony next. Okay, thank you. Okay, so we're going to go ahead and proceed to testimony. Do we have anything? And the chair will call Derek Cohen. And good morning, sir. At the top, if you don't mind, just name who you're here testifying on behalf of, if anybody, and if you are on for or against the bill.
Absolutely. Derek Cohen, Vice President of Policy for the Texas Public Policy Foundation, here in support of HB 3758. Since obviously we're talking about this practice more generally, this is the broadest bill that we have before us today. We can go over the general guidelines we've talked about in previous bills. One, that obviously forfeiture proceedings can be initiated and completed without any criminal charge. Essentially, it is a soft on crime policy insofar that it actually focuses on property, on contraband, rather than any instrumental evidence or on seeking a conviction itself. It leads to bad local budgeting. You know, a lot of times we see that some of the wants and needs tend to get mixed together when it comes to this particular thing coming out of a local budget, and things are getting supplanted by Article 59. It creates a fundamental asymmetry in the law that allows low average forfeitures to actually require more effort, more money, more resources to fight it than the actual value of the property that would be in return. And we also know that $34 million of this has happened in the most recent report here in Texas, but we're not really sure how much of that was pursuant to any criminal activity, absent any reporting, which I'm sure we'll discuss later. And so this bill specifically would eliminate civil forfeiture as we know it, replacing it with a robust system of criminal forfeiture. And when I say most robust, I mean it also has some of the most robust exemptions as well. It does not allow for the forfeiture of homestead properties, of vehicles less than $10,000, should such exist anymore these days, but also $200 in cash as well. more importantly, pursuant to the Timms decision, it actually establishes a proportionality standard. In other words, is the property being forfeited proportional to the actual crime being alleged, obviously now requiring that nexus of that crime. It also has a very robust innocent owner process, as we've discussed previous. The only correction that I would make in this bill, and it's a minute correction, is in 59004, the exempt property, whereas item 3 reads U.S. currency totaling $200 or less. I think a more thorough way of addressing that is currency valued at $200 US dollars or less. Thank you.
Thank you very much for being here. Members, any questions for the witness? So on 59804, I heard the small suggestion change there.
Mm-hmm.
Do you have any comments, thoughts about the propriety of 1 and 2?
And that would be the homestead property.
Homestead, and you briefly referenced the vehicles attendant.
Yeah, vehicles, and so that's a bit of an arbitrary number, because I know, and then people who have litigated this, I know Mr. Ponju's here and registered to testify on this as well, and I would implore him to speak on this. But usually we see the average value of forfeiture, specifically in some of the major counties, tend to be either triple digits or low four figures. And in that case, this would actually prohibit my interpretation would be basically the Blue Book valuation of whatever that particular vehicle would be. Now, again, that's a bit of a subjective estimate, but I think that having that floor, similar to what we've seen in other bills that have been heard before this committee, is something you need as well, because again, if something is truly contraband as in an instrument of a crime, then that still will be subject to forfeiture. It's where do you set that limit? So it's, we're getting I would say the more of the proceeds as opposed to the clunkers,
Okay, and this is a very broad bill.
Yes.
And I think all of us on the dais, as well as probably all of my colleagues in the broader Texas House, want to make sure that law enforcement is able to do their job to keep our streets safe and keep violent criminals off of it.
Absolutely.
Would you anticipate that there would be any adverse impact on law enforcement agencies across the state to be able to do their mandated mission of keeping us safe?
No, absolutely. And again, I'm going to draw the answers that I have.
Sorry, you said no and absolutely, which...
No, I'm sorry. No, I do not believe this will compromise law enforcement's ability to keep us safe, and absolutely, I think they will be able to continue on in that mission.
Thank you for the clarity.
And that reason for that is thus, because I think that what this actually reinforces is the standard around the process. It doesn't necessarily stop the seizure from happening. It doesn't stop the inquiry into that. What it actually does do is it compels criminal charges being brought forth. And like I've said to this committee prior to, we want to see the guilty being held to account, but the only way we can do so is to make sure the pendency of the normal criminal justice system.
Thank you. And one point, just for the record, I need to clarify that we're only speaking on this bill at the moment.
Yes.
We're good.
Only pursuant to 3758.
Correct. Thank you very much. Thank you. Any concerns about, because proceeds from forfeiture do end up in law enforcement
Yes.
agencies, any concerns about this potentially defunding their ability to execute their mission?
No, and there's two reasons for that. The first reason being is that if you look at it in terms of a budgetary process, that actually needs to be basically fully cooked before we even start talking about any sort of supplementation of the Article 59 funds. And that's actually in Article 59 as it's currently written.
Great.
Now, secondly, I would also say that this is the problem that we have with the fungibility and the wants and the needs, is that stuff needs to be fully funded up front. And after HB 2200 of the 87th legislature, that is actually mandated in law and then subject to certification by the comptroller to ensure that that actually is not working in the other direction in anticipation of any funds that may or may not appear in the Chapter 59 account.
Thank you very much. Members, any other questions for the witness? Thank you very much.
All right, thank you.
Okay, wait, sorry, which one? Got it. Okay, and let's go ahead. The chair would like to call Arif Panju. Thank you. Good morning. If you don't mind, name, organization you are with, and if you are on for or against the bill.
Good morning, Chairman. Good morning. I'm Arif Panju with the Institute for Justice. We are for the bill. I think there's two good features about this bill that I want to highlight, and I agree with everything my friend at TPPF said, Derek Cohen. One is that it addresses what's at the heart of the problem with civil forfeiture under Chapter 59, and that is the profit incentive. Allowing a branch of government to fund itself by exercising the police power poses a threat to the separation of powers. It distorts policing priorities, and it raises due process issues. I'm just going to quote one quote from Judge Willett. Judge Willett on the Fifth Circuit was on the Texas Supreme Court, and here's how he described the problem. It was the earmarking feature added in 1989 that sparked the explosion of Texas forfeiture actions. Law enforcement agencies and prosecutors can agree to split the revenue for their own use, end quote. Indeed, that is a problem. And that's why when you look at prior studies on this, including from the Court of Office Administration, they concluded that it distorts the budgeting process. Here's some quotes from the Office of Court Administration. Quote, some DA offices rely on forfeiture for a significant portion of their overall revenues. Several of the interviewed DAs conceded that forfeiture funds can complicate negotiations with their commissioner's court. Half of DAs surveyed use forfeiture money for office salary support. The significant and widespread use of funds for this purpose affirms that forfeiture accounts are viewed as a means to offset operational costs or for counties. That's a problem. That will be addressed by this bill. The second thing I want to point out is that there's a very big imbalance between an individual property owner and a prosecutor when that prosecutor steps into civil court and waves around criminal allegations and uses civil discovery to try to take people's property. The problem really takes place where there's the absence of constitutional safeguards. When you go back to criminal court like the bill contemplates, you get away from that. And again, according to the Office of Court Administration, again, prosecution of forfeitures in civil court, quote, makes it extremely difficult for asset owners to recover their assets in a forfeiture hearing, even if their claims to the assets are legitimate. I'm just going to highlight 3 quick reasons for it without going into them. The report highlights one of the big problems: property owners are not entitled to legal representation. There's a bill addressing that with the fees later today. 2, instead of meeting the beyond a reasonable doubt standard, the standard is low. And finally, no criminal conviction is necessary. The concerns were also flagged by the committee, the study committee the House had. We think ultimately this is a great bill because it solves a lot of these issues. And we'll talk about later why there's not more data to point to, and that's because there's no real reporting, but there hopefully will be soon.
Great, and thank you very much for the testimony. Just got to clarify for the record, we were only speaking at the moment on this particular bill, HB 3758, which is before us. Members, any questions for the witness? One question, because similar thing to the question I asked the previous witness, which is, I have so much respect for the men and women who put on the uniform and exercise their duties as a law enforcement officer or official in the state of Texas. I'm very concerned about any bill that, even if it's unintended, may have an adverse impact in terms of their ability to keep Texans safe. And we are dealing, unfortunately, we're in a state that there is a fair amount of criminal activity. We have organized crime. We have cartels, especially near the border. Is there any concern that a bill like this might impede their ability to deal with those types of bad actors, especially?
Not at all. And I think it's because it recenters the focus on the policing priorities where they should be, which is to obtain convictions and fight crime, and leaves the funding of law enforcement where it should be, which is with the legislature or a body that is voted and elected and then appropriates the money and funds their department. Intermixing and allowing law enforcement to raise their own funds and intertwine themselves in civil court and criminal allegations distorts attention away from core priorities. So this would actually help.
And I doubt you would dispute, though, that, I mean, a lot of these criminal elements frequently use stolen vehicles. They use cash for their transaction. Would this bill make it too hard for us to go and, get these either ill-gotten gains or materials or assets that we just, are likely being used in criminal enterprise?
Not at all. The basis for any forfeiture has to allege forfeitable crimes. And all this bill says is, you're going to go ahead and pursue the crime, and that's it.
So if somebody is breaking the law, using assets to do it, law enforcement, from your perspective, would still be able to go and take that from them to stop them from, endangering Texans across the state?
Yes, in criminal court, along with the arrest as well, and pursuing the arrest in criminal court, along with the property and the seizure there.
Do you think it's too hard, though? Is it too high of a standard to have to go into criminal court? Is it unnecessarily burdening law enforcement?
Absolutely not. Whether you look at it through the lens of Article 1 of our state constitution, which presumes liberty and has hedges against interference by government, we're there to protect liberty and property, not to subject some property owners to losing theirs to reach some efficiency with policing. Or whether you view it through just straight policymaking outside of the constitutional lens, what you want to do is focus the priorities on what the people want, which is to fight crime and lower crime and give all the resources necessary. To try to ask law enforcement to, in addition to that, raise their own money through forfeitures, I think then distorts what the priorities are. It's perfectly fine, and they should pursue forfeitures when there's crimes, and nothing in this bill would prevent that. In fact, it would segue everything into the criminal courts where you can actually obtain the convictions and stop those people in the first instance.
Is there no way you think this might incentivize criminals to either continue in their criminal behavior or increase the likelihood they may engage in crimes, given that the standards of proof that are contemplated by this bill may be affected? Maybe from their perspective, they might think it's harder for law enforcement to get their assets?
Not at all. If you commit the crime, you're going to lose the property, period. If you abandon your property, you're going to lose your property. If you want to show up in court and try to get your property back, you're going to be in criminal court trying to get your property back. So it does not help criminal elements at all. It just recenters things the way they were before 1989 when Judge Willett pointed out things went sideways.
Thank you very much. Members, any further questions? Thank you very much. Okay, and Chair, at this time, we'd like to call Angela Beavers. Hi, good morning to you.
Good
If
morning.
you don't mind name and organization you're here on behalf of, if any, and if you are speaking on, for, or against the bill.
Okay. Good morning again. Thank you, Chairman Harrison and members of the committee. My name is Angela Beavers. I am here representing the Harris County District Attorney's Office in opposing this bill, 3758.
Thank you.
I am a prosecutor with the Harris County District Attorney's Office. I am currently the chief of the Asset Forfeiture Division. I've been with the office now for 27 years, and for 21 of those years, I've been practicing in the Asset Forfeiture Division, so exclusively asset forfeiture law. Because of my experience, I've seen firsthand how asset forfeiture, as it is written in Chapter 59, is an effective tool in making sure that criminals do not profit from their crimes. I would welcome any questions about any aspect of asset forfeiture, but to first address the bill that we're hearing at this time. This bill repeals civil asset forfeiture as it is now in Chapter 59 and replaces it with criminal forfeiture that would be filed in criminal court. There are two major overarching reasons why placing asset forfeiture into the criminal system is not a good idea. As it is now, there are two entirely separate proceedings that go on, okay? We've got the criminal case against the person, whether or not they committed the criminal offense. And then on the other hand, we have over in civil district court, we are determining the nature of the property. Is this property contraband or not as defined? And in our cases, 85% of those cases are going to be drug related, right? Dealing cocaine, heroin, fentanyl, or whatever. So we're basically deciding, is this drug money or not? So the separation allows for a more fair and ethical disposition that is not dependent upon each other, right? It promotes unethical plea negotiations. For example, it prevents the defendant from the separation prevents the defendant from trying to buy his way out of a criminal case, right? Oh, I'll waive all the money, but give me a lesser offense or dismiss my case. On the converse, it also prevents a prosecutor from making an offer in the criminal case that's contingent upon the money, okay? Hey, if you'll waive your right to the money, we'll give you a misdemeanor instead of the felony, or we'll dismiss your case, okay? So it prevents that kind of unethical plea negotiations. You know, I don't tell my criminal prosecutor colleagues what they should do on their criminal case. They don't tell me what they should do, what I should do on the criminal proceed case. Second, this requirement, the requirements of this bill will require thousands of asset forfeiture cases to be filed in criminal courts that are already overburdened in our criminal justice system, especially in Harris County with all our, the flooding, the hurricanes that we had, COVID. We're in a backlog right now. We're making inroads, but it's still a huge backlog. Adding these thousands of forfeiture proceedings to the criminal dockets would only see that justice is not served for criminal defendants as well as the civil forfeiture litigants. And at this time, the civil district courts in Harris County have no problem handling these forfeiture cases. They do so with ease and efficiency. So those are the two main reasons. It also adds a requirement of a conviction in the criminal case in order to forfeit the proceeds of the crime. There's only about 10% of our cases that do not have a criminal case associated at the time. It's a very small percentage, but when there is that circumstance, it's for good and valid reasons. There may be a huge federal, state investigation going on, and to charge that person at the time might jeopardize that investigation. They might want to turn that person into a confidential informant or something. But there's a lot of reasons why a criminal case might not be associated at the time. But this requires and it incentivizes overcharging. Okay? Oh, if I want to, divest this criminal of his criminal proceeds, I've got to charge him with that specific offense or an offense. So those are the main reasons. I'll entertain any questions.
No, thank
I'm
you
done. I got the red light.
No, and then thank you and thank your office for your contributions to law enforcement safety here in the state. One question, since you mentioned contraband, as I have perused the bill, there are provisions that do implicate contraband. Is it your understanding from the bill that contraband would not still be subject to seizure?
No, it is subject to seizure.
And under this bill?
And forfeiture. Yes, it's, contraband right now is defined as any property used, intended to be used, or the proceeds of a felony offense. It just makes it, easier. This bill makes it easier for the criminals. And it promotes a lot of unethical overcharging, unethical plea bargains, overcrowding.
The one thing that has come to my attention, having now heard many bills on the issue, and of course we're only talking about HB 3758 at the time, but one thing that might help us as we contemplate bills like this is knowing what happens on the other end of a civil proceeding. So let's assume you're able to keep the assets that resulted from the civil proceeding. How are these assets typically disposed of? What types of things does your office spend the resources that you have as a result of these proceedings? Where does the money go?
Chapter 59 dictates that it has to be used for law enforcement purposes, okay, or for the official purposes of the DA's office. So, things like body cams, body armor, bulletproof vests, training, those kind of things. For our office, we use it for training, for hiring expert witnesses, maybe in a capital murder case for future dangerousness. What my office has been doing is, and I'm very proud of this, we've been investing the proceeds of crime back into the communities that are most hurt by crime. We've been donating our funds for crime prevention purposes, to help domestic violence victims, for drug rehabilitation programs, for juvenile diversion programs, for Crime Stoppers. So that's a big part of ours that is used for crime prevention within the community.
Thank you. You mentioned that did I hear you correctly, that 90% of your civil proceedings are also accompanied with a criminal charge?
90% have a criminal charge associated with them, okay? It might not be the exact, like a drug charge. It might be a felon in possession of a weapon, and we choose not to charge the lesser drug charge. But there is a criminal charge associated with those 90%.
Of the 90%, how many of that 90% go on to receive or be adjudicated a proceeding that would terminate with a criminal conviction of the 90%?
It's hard to say. We keep them separate.
Correct.
And I can certainly dig in and get those stats for you, but there's so many factors in a conviction. Maybe they're pleading to one charge that's unrelated and they're dismissing, the drug charge because they have 8 or 10 charges, right? So they might plead guilty to one and not the other. We have, different judges or something.
Sure.
But there's a lot of factors in why there might not be a criminal conviction, not because the property is not contraband or they're not guilty, but for other valid reasons.
But when you say not guilty, they haven't yet been adjudicated by our judicial system as being guilty, though. Is that correct?
When the proceeds may be forfeited.
Correct.
In Harris County, what the practice is, we have an informal agreement with a defense bar that if they want to, we will hold off on the civil case until the criminal case is done. Because after all, the criminal case involves, the liberty of the defendant. So we will honor that. If they want to wait till that is done, then that's fine. And then we'll start with our civil case so they don't have to testify in both and be caught in that position.
Yeah, and I just want to make sure I heard you correctly, though. But if 90% of these forfeitures also accompany some type of a criminal charge, would a law like this really change that much then? If 90% of the cases you've already got a criminal charge and presumably a criminal proceeding, or should I not necessarily assume a criminal proceeding?
I don't think you should assume it there, or what happens to that criminal case.
Right.
For so many reasons. Maybe a witness is missing or something. But yeah, it is a small percentage, and that's good. But to make it dependent upon a conviction, I mean, that creates all sorts of incentives not to do the right thing, right? Let's get that conviction, because it's dependent upon forfeiting the criminal proceeds.
But it is unambiguously true. I mean, it's almost axiomatic at this point. I mean, we do have people in your jurisdiction who are having their assets seized absent a criminal conviction.
Yes, and that's 10% of those cases. And,
But even in the 90%, if I heard you right,
okay.
there's not necessarily a criminal conviction in the 90% where there's a criminal charge. Is that right?
Yes.
Any idea just roughly of the 90%, how many of them actually end up with a criminal conviction?
I'm sorry, I do not have that. Now,
Even a ballpark?
especially in Harris County,
Yeah.
there might not be a conviction. We have a lot of diversion programs.
I'm just, is it a majority of the cases that have a criminal charge? So the 90%
Oh,
there was
yes.
a criminal charge, it's a majority that end with a criminal
I would
conviction.
venture, yes, sir, I would venture to say that it's going to be the majority that do come out with some kind of conviction, maybe a deferred adjudication where they pled guilty, which I don't consider a conviction, and technically it's not if they can successfully complete it, but I do think there is some kind of criminal consequence.
Okay. It's, in these types of cases on the civil side, it's the Harris County or the state of Texas, who's being charged or what is being charged in a civil proceeding?
Well, it always arises from the criminal episode, right? So we do have to prove in our civil case the crime that happened, okay? But in civil court, like I said, we are litigating what is the nature of this property? Is it contraband or not, as defined under the statute? So that's why we do have a lower burden. I mean, we're litigating is this drug money or not? We're not litigating somebody's liberty, okay? We are litigating whether or not the property was used, intended to be used, or the proceeds from one of the felonies listed in Chapter 59. And it's the majority of those are felonies, not misdemeanors.
But in the actual civil proceedings, who or what is actually being charged?
Okay, well, it has a funny little name of state versus $50,000, state versus 2007 Mercedes McLaren, something like that, right? So it's actually against the property. But then what we have to do to provide due process is we have to give all owners and possessors notice of the lawsuit. Just like you see in the movies where they go and say, you've been served, we've got to serve them with process and to serve them with notice of that lawsuit so they're able to come in and contest the forfeiture if they want or not.
Thank you. But we are talking about charging in these cases anyway, the way Texas statutes are currently structured, construed, and implemented. We are, in fact, charging inanimate objects. Is that correct?
I wouldn't say charging, but yeah, it's about the instrumentalities or the proceeds or money that is used in the commission of an offense.
Okay, and so 90% of the time there is some kind of a criminal charge somewhere, and at least 10% of the time, if I heard your testimony correct, there is no criminal charge. Is it conceivable that under the current state of Texas statutes, innocent people are being deprived of their assets and their property?
Is it conceivable?
Is it conceivable?
I would hope not, but we're not perfect. Nobody is. So, but there are a lot of due process protections to make sure that that does not happen that are already built into Chapter 59. You know, first of all, in Harris County, out on the street, the officers have to call me, call one of my prosecutors and go over the case and make sure that the seizure is valid. Then, you know, we have to, like I said, name all owners and possessors and give them notice. They are served with process. This tells them exactly what they have to do. You know, they can just call me up and say, hey, I'm contesting this. You don't have to have an attorney. A lot of them have their criminal defense attorneys. So that's, you know, another due process protection that is involved.
And I just, as a committee, we're contemplating what, if any, emendations may be necessary or advisable for Texas statutes on asset forfeiture. In the scenario that you just described there, though, the stuff, the property has been at that point seized, and the bill does contemplate certain changes to standards and burdens of proof. It is very foundational to our criminal justice system, both in the state of Texas and in the United States, that there is a presumption of innocence until proven guilty. If I heard you correctly, in at least 10% of your cases, there is not even the allegation of a crime. That's correct, right?
There is the allegation of a crime.
But there's been no
And we still have
charge,
to
right?
prove it.
But there's been no charge in at least 10% of your cases, right?
Right.
And so not a charge, but also not an adjudication of guilt.
No, there is not on the criminal side.
Right.
No.
But we are having, under current, again, I'm trying to contemplate Texas statutes as they stand today and the proposed emendations here before us. Because we obviously want guilty criminals to be prosecuted, and we don't want them to receive the fruits of their ill-gotten gains. We want to take their instrumentalities of the things that they used in the commissions of the crime. But in 10% of the cases, the state is not alleging a crime, much less having a conviction. So I'm curious your thoughts on if somebody's property has been seized, yet they're not charged with a crime, they're not adjudicated to be guilty of a crime. From your perspective, what does that do to our fundamental presumption of innocence until being proven guilty if they show up with that paperwork, and then now they have a burden to prove almost a negative? I'm just curious your thoughts on what that does to that principle.
Well, like you said, the proceeding is against the property. It's not guilt or innocence of the person. So, you know, when they come in, we still have the allegations, and we still have to meet the burdens of Chapter 59 about what that that criminal activity is, okay? I still have to prove if it's money laundering and they haven't been charged with money laundering, I still have the burden of proof to prove in my case that they were money laundering. It's not, they don't get a free, get out of jail free card, or I don't either. I still have to prove that. The burden is never on the owners and possessors initially. The only time the burden shifts is with the innocent owner defense, okay? And that's common in the law. Affirmative defenses, like self-defense, right? We still have to prove it's murder, but then if it's self-defense, then the burden shifts to the defendant to prove, hey, I was justified. They were coming at me with a pistol or a knife, and I had to shoot them to save my life. So it's common, but, you know, what we are able to do in the civil world is we are able to have this civil discovery that really gets us to the truth, right? They don't have that in criminal court. So we can get there and make sure that we have justified cases, okay? If there is an innocent owner, all they have to do in my jurisdiction, in my division, come talk to us. Bring your attorney in. Let's talk. Show me what it is. You don't have to hire an attorney if you don't want to. Just come and talk to us. Because the last thing we want to do is seize property, right, that's not contraband or from innocent people, innocent owners. That's the last thing that law enforcement and prosecutors want to do.
But it still would be, even in that instance, it's a burden or a requirement placed on somebody who has committed no crime, yet they do not have their property. Is that correct?
Once once the burden shifts.
Sure, and the burden, and it's tricky, and that's why I was asking who or what is being charged, because, again, we're talking about inanimate objects. I mean, maybe I'll pose this as a question. I mean, can an inanimate object commit a crime?
No, but it can be involved in it, and it can be the proceeds of a crime. Because, yeah.
Last question. Are there any provisions in this bill that you could support?
I think the bill as a whole, and I'm respectful of you, Ms. Thompson.
And actually, let the record, Representative Toff. Oh, sorry, no, never mind.
The bill, just as a whole, it just makes it easier for criminals to keep the proceeds. And so, you know, and the points that I brought up before is why we are opposing it.
Well, thank you for the time, and thank you for your answers
Okay.
to my questions. Members, any other questions? Thank you.
Right. And if I may, I don't know if this is a time to do it. I know I'll be speaking on other, I have some materials that I'd like to maybe provide. Let's see. So I know this is just a paper on, you know, maybe the facts about asset forfeiture. A lot of times we're up here, you know, trying to debunk some of the myths and the false narratives. Sometimes it's not easy, you know, going into the intricacies of the law. So, I mean, it might not be pretty, but that's, you know, that's a paper that we've written. I've got my card on there. Anytime, give me a call if you ever need any kind of perspective on the prosecutors.
Thank you very much for being here, for sharing your perspective on HB 3758.
Thank
All right, at this time, Chair would like to call James Smith. Good morning. Thank you for being here at the beginning. Most importantly, thank you very much for your service.
I appreciate it.
If you don't mind, name who you are testifying on behalf of and if you are on for or against the bill.
Yes, my name is James Smith. I'm a sergeant with the San Antonio Police Department, and we are respectively opposing this bill as a department and also as myself. And I've given testimony here before. I'm not going to try to repeat too much what I've said, but try to stay on this bill. Just as a matter of reference, I have been the asset forfeiture sergeant for over 15 years in San Antonio. And like my counterpart had just stated earlier, the whole premise on a lot of these forfeiture bills this session, including this one, is that something's wrong with Chapter 59. I'm not here to say that anything's perfect. There's no legislation that's perfect. That's why we're up here every 2 years, is to make legislation more workable and more adaptable and make it more efficient. But I will tell you, this law has been vetted over the years. There have been tweaks to it, and it's a good bill, and it's a great tool for law enforcement. But it goes beyond being a great tool for law enforcement. It goes to be a great tool to create a good quality of life for our individual citizens. This bill, as stated earlier, this isn't a reform bill. It's a 100% repeal of what we currently have, in the being that it's civil. It's civil in nature, and things just aren't broken. And I'm one of those guys. If it's not broken, let's not fix it. Okay. Now, if there are tweaks and there's always lessons learned, yes, let's look at those individual things that need to be tweaked. But this bill, if it was to go forward, doesn't make Texans safer, doesn't make them more secure. And I'd like to address how we do things operationally in San Antonio. You brought up it was an important fact, and it gets brought up a lot in here. We're just taking innocent owners' property. That doesn't happen. We're not redcoats going in there proactively knocking on people's door and taking items. Every one of our cases that we file has to have a nexus to a Chapter 59 offense. Has to have that. If we don't have that, we're not going to file it. If we lose the evidence on the criminal side, we lose the evidence on the civil side. Innocent owners. Every day we return cars. First things we do, we see what cars were seized. We get a list from the pound. We look, hold on, this isn't the name of the individual that got arrested. We make that proactive attempt. We get a hold of those owners and say, hey, do you know about Johnny? he had your car last night. He was stopped with a kilo of cocaine and $10,000 in cash. No, I didn't even know he had it. We released that car back to him. Now they have knowledge if that car is used again, then we would be able to seize that. We also, every day, our office is contacting lien holders, be it GM Financial, Toyota. That car belongs to them. A lot of folks, we don't realize there's a jeopardy clause in our contracts when we take a loan out on cars.
I think we're at time here.
Oh, I'm sorry.
No, it's okay. Thank you for being, and members, do you have any questions for the witness?
That was a quick 3 minutes.
Really appreciate you being here.
No, I appreciate it. Thank you very much.
Thank you for your service to the citizens of San Antonio. All right. Okay, is there anybody else who wishes to testify on, for, or against HB 3758? All right, if not, I did not see any. The chair would like to recognize Representative Thompson to close on her bill.
Mr. Chairman and committee members, thank you very much. I was sitting there listening to this wonderful testimony of my opponents, and I was just thinking back in the files of my mind. Can you imagine, somebody stopping you and say, okay, you got $500 on you, and we can either charge you or you can just forfeit your $500. A lot of times people just walks away from that money. Merely because they have cash money on them. A lot of people get paid in cash. We have people who work on different jobs, and they pay those folks in cash. They don't have a bank account. So if you get stopped and they say, where you get this cash money? Well, I just made it. Well, who are you working for? Where's your pay stub? You don't have a pay stub. Okay, they may charge you with a crime. You can't afford to keep going back to court. They keep saying, well, we won't reset your case, we're going to file you this on you or that on you. And then when you know anything, you go to court 2 times, you've lost your job. Or if you have a significant amount of money. We had a case in Texas, if I remember back, a few years ago, about 2013 and 11. Guy was an evangelist, and he was going across the state holding tent meetings, and he had a significant amount of cash with him. He's going to another town, and he got pulled over for speeding. And they took the money. He had to go all the way to the Supreme Court of Texas to get his money back. Most people can't fight those kind of cases. In the end, he hadn't committed no crime. He just happened to have cash money on him. That was the crime. He had cash. So I just believe that if it's a legitimate situation where a person has committed a crime and been charged and convicted of it, and the assets are part of that, and they're forfeited, I get it. But just taking people property without any crime or conviction or something like that, I don't understand it. You got a Lamborghini and you speeding, so we're gonna charge you. Where you get this Lamborghini from? It's a gift. Well, where they get the money from to buy you a Lamborghini? They seize your Lamborghini. Now you got to go and prove that's your Lamborghini, and maybe it's a gift from your family. They got to go to all the court for all of this kind of stuff. They're still going to forfeit that Lamborghini. That's not fair. So all we trying to do is put some fairness in this game. We're not trying to stop the police department from doing the things that they need to do to keep us safe and to do the things that they do to fight crimes. But in the meantime, we don't want them treading upon people's rights because they can. I close.
Thank you very much, Representative Thompson. And since you were not here to lay out your bill, members, do y'all have any questions for Representative Thompson? Thank you very much, Representative. Oh, no worries, no worries. Thank you. Okay, if there is no objection, the bill will be left pending. Is there any objection? Hearing none, HB 3758 is left pending. Thank you, Representative. All right, the chair lays out HB 1874 and recognizes Representative Noble to explain her bill. And the chair offers a committee substitute to HB 1874.
Thank you, Mr. Chairman and committee. Thank you for letting me lay this out today. And I want to echo what y'all have already said. I am so grateful for our law enforcement and the job they do and how hard it is to get this particular issue correct. And I'm so grateful for our DAs and others that do make sure that bad people don't have these resources available to continue to do bad things. So this bill doesn't want to do away with that tool. In fact, I think that civil asset forfeiture is a valuable tool for law enforcement agencies. However, sometimes lawful Texans have their property seized, and they may be required to pursue a costly legal process to get it back. In the case of a wrongful civil asset forfeiture, once discovery commences and upon the determination of a judge, this bill would award reasonable attorney fees to the rightful property owner. You know, our goal is that when there's a bad seizure, that it's immediately returned, right? That it goes back and that there's no foul, no harm. But this is once discovery commences, because that is when you as a Texan would have to engage legal counsel. The law enforcement agency that executed the seizure would be required under this law to pay for reasonable attorney fees as determined by the court out of their seizure proceeds funds. It has been brought to my attention that sometimes there's a plea deal or a dismissal as part of a plea deal, and I would be happy to bring a committee sub to clarify that in such cases, this bill would not apply if this committee deems that necessary. Again, this bill is to protect lawful Texans. They should not have to go into the hole when they've had their property wrongfully taken by those that are working on behalf of our state. I'm happy to answer any questions, and I reserve the right to close.
Thank you very much, Representative. Members, any questions? Thank you very much. All right. Okay, the chair calls James Smith. You should not have gotten too comfortable back there. Thank you a bunch. And if you don't mind, again, for the record, name who you're testifying on behalf of, if anybody, and if you are on for or against the bill.
Yes, once again, my name is James Smith, a sergeant with the San Antonio Police Department, who I'm representing today, and we are opposing this bill. You already know my history. I've been doing this for over 15 years. Appreciate y'all hearing
Real
this
quick,
bill.
sorry to interrupt you, officer. I have you registered both to testify on behalf of the San Antonio Police Department and yourself.
Yes,
Is that
yes.
correct?
I apologize.
Nope, thank you very much.
I apologize. No, I'm just going to speak about how this works operationally. Once again, when we have innocent owners, we take care of that at the beginning. We really do, but we have to get that property seized, because if we don't have it in the proper room and filed on within 30 days, it loses its status as contraband. There are many cases where we're generating offense reports, other evidence, and throughout that time, once we find out it's not a seizurable case, we return it. We do that consistently. And we also have the filter of the DA's office to do this. I can't even hardly remember of any cases where after the fact it's adjudicated at, oh, this was just innocent owner's property later on. I'll be honest with you, I just don't think the state legislature should be a place where we have a guaranteed revenue income for attorneys. Attorneys are taking cases. They'll take personal injury cases. They know there's some risk involved. The attorneys are getting paid in these cases. They are. If there's $100,000 taken in a case, they'll go to the civil side and they'll make a plea deal to get some of that money back. This is how it works operationally out there. A lot of attorneys don't like the fact that it's in the civil proceedings. They would much rather have it in the criminal proceedings, because the criminal judges are a lot more lenient with some of that money, which these individuals could get paid for. But just philosophically, and then reasonable. What are reasonable attorney's fees? I wouldn't sign a loan when the loan said, well, we're going to give you a reasonable interest rate. Wouldn't do it. And this is going to take money away from the citizens. We generate not a lot of revenue from this. You hear the big number, 34 million. Our agency, maybe $1 million. Our entire police budget is probably about $1 billion. I always go back, This is going to hurt cases where we seize the criminal instruments. And I believe I've said this before. The DWI force, that is a huge one. Where we seize those cars, we don't care if they're wrapped around a pole. We don't care if they have a $500 limit. We're going to seize those cars. To me, this is another end around just to try to quell agencies from filing good cases. But I'm just, philosophically, I'm just opposed that we are, as a state body, that we're making a revenue stream guaranteed that it's a win-win situation for the attorneys out there. If they win the case, they're going to already have that negotiated with their client. If they lose a case, or if it's dismissed, and like I said, there's so many things. It could be a agreed judgment. It could be for the interest of justice, where these folks are going to end up working the case later on down the road, but it will show as a dismissal. But to actually have a revenue stream for them embedded, I have an issue with that, and as the agency we do too.
And thank you very much for being here. And since you were talking about your philosophical objection, I'm just curious, if somebody, because in these cases we're talking about people who had their property seized,
Yes.
they were involved in litigation to get it back, they were never convicted of guilt in the commission of a crime, and they received their property that is rightfully theirs back. You have a philosophical objection to them being made whole for having to go through a process to get their property back.
Well, as we said earlier, as earlier testimony had said, it doesn't have to be a final conviction. I'm very confident of our process. They will get their property back. Ours, in our cases, I can tell you, that property will be given back to them probably 30 days.
Well, and maybe I'm misunderstanding the bill, but as I understand it, it would be applying to somebody who was innocent owner. They had to go through litigation to get their property back. So there's not a question about whether they were finally adjudicated to have committed a crime or not. It's a question where, at the end of litigation, the judicial system said, no, you are rightfully entitled to this property. Therefore, the state did not have the right to keep it. It's yours. It was yours. It's taken from you, and we're giving it back to you, but you had to incur potentially significant expenses
I would tell you,
to get it back.
in most of these cases, they have the same attorney working with them on the criminal side as they are on the civil side. As I said earlier, we're not going to file any cases that we don't have the underlying criminal case. We're just not going to do it. It's not worth it. And I may have said this in past testimony, this is what we learned a long time ago on the criminal side. We're going to let a whole lot of guilty people go free, so we don't take that chance of ever convicting an innocent person. That's the same standard we use in San Antonio. We're going to give that property back. If we think there's any chance of that belonging to an innocent owner, that's going to go back. We just don't want to make that mistake. There's always another day. And there's a lot of these cases we go, I think this guy probably is, this probably is contraband, but the case isn't good enough. And as I said earlier, if we lose the case in the criminal side, we can't proceed with our case. And so many of these cases, we probably get 1,000 cases a year, and maybe we file 250.
All right, thank you very much. Members, any other questions for the witness?
Thank you.
Thank you. Chair would like to call Angela Beavers. Welcome back.
Thank
If
you.
you don't mind, again, just for the record, name, organization you're testifying on behalf of, and if you are on for or against the bill.
Angela Beavers. I'm here on behalf of the Harris County District Attorney's Office, and I am testifying in opposition of House Bill 1875.
Thank you.
This bill dictates that attorney's fees be assessed against law enforcement when a forfeiture case is either dismissed or found not to be contraband. We always have to think of the effects, right, of bills, of laws. The effect of this bill will be to discourage dismissal upon the discovery of new evidence that is property that is not contraband that may arise after the forfeiture proceeding is filed, or when an unknown innocent owner makes a claim after the forfeiture case is filed. Okay, so we only have 30 days from the date of seizure to file our forfeiture proceeding. After that, if some new evidence or maybe an unknown innocent owner appears, we have to be able to have the ability to dismiss and do the right thing without the penalty of having attorney's fees assessed to law enforcement. Okay, if we don't have that, then there's an incentive not to do the right thing. And so that's the effect that this would have on them. As far as the part of the statute where attorney's fees shall be assessed upon a determination that the property is not subject to forfeiture, this would probably commonly come forth when there's a trial in the case. It goes all the way to trial, and then one side prevails against the other. The general rule in civil law, as it is now, is that the non-prevailing party has to pay costs and attorney's fees to the prevailing party. If attorney's fees are to be assessed when they just to law enforcement and not according to the law, it's not fair. I mean, it's just a one-sided assessment of fees. If we're going to choose to assess attorney's fees, why not make it fair? Loser pays. That's the prevailing law in civil cases.
Thank you very much. Members, any questions for the witness? Thank you very much for being
Okay,
here.
thank you.
All right. And at this time, the chair would like to call Arif Panju.
Mr. Chairman,
Thank you. And if you don't mind, again, for the record, name, who you're with, and on, for, or against the bill, please.
I'm Arif Panju with the Institute for Justice. We are for HB 1874, I believe.
1874.
In civil court, the playing field is completely at odds for the individual property owner. We have prosecutors who step into civil court, wield the power of a criminal offense, even when there's no charge. And then you're forced to make a decision as the individual. Do you try to hire an attorney to get your money back? That's a financial question sometimes, depending on how much was seized and how much you're going to have to pay. Or what's usually the case, since you're saddled with discovery requests and a forfeiture complaint, you have to deal with it in some way, shape, or form. But if you do go through all of that and you get your property back, you should be made whole. If prosecutors are allowed to go into civil court and have lower burdens of proof, be able to keep the proceeds in their own budgets, when they are unsuccessful, you should be able to recover your fees and be whole. I think one thing that is particularly notable, what we just heard, is there was a great question about what the effect of this would be. And I think what I heard right is that some prosecutors would be incentivized not to produce evidence that something is not contraband. That's shocking. Prosecutors are statutorily required to pursue justice, not convictions, not forfeitures, but to do justice under the state's name. If there is evidence that it's not contraband, that absolutely should be divulged to the other side. The fact that the other side can get attorney's fees and be made whole should not deter a prosecutor ever from withholding evidence that something is not contraband. That was shocking. I also think it's notable that on Harris County's docket, for example, you'll see agreed orders where people who have gotten attorneys secure settlements. Settlement goes something like this. You agree that all of this money is contraband, but we're going to give you half of it back to settle this case. All of it's contraband, but half of it you get back and you can go away. And that's what happens when people try to fight for their rights and get their property back and bring claims addressing what's going on here under the statute. They make them go away by throwing some of the money back and keeping the rest. Absolutely, if someone prevails and gets their property back and the claim is dismissed, the state acquiesces and doesn't pursue the property. If someone had to pay an attorney to make that happen, to protect their rights, they should be made whole in this state. Thank you, Your Honor.
Thank you very much. Members, any questions for the witness? Thank you very much. Chair would like to call Derek Cohen. Thank you and welcome back. Again, for the record, name, organization you're testifying on behalf of, if any, and on, for, or against the bill, please.
Absolutely. Derek Cohen, Vice President of Policy at the Texas Public Policy Foundation, here in support of HB 1874. Not much I can build on and what has been said by Arif and with Representative Noble's outstanding layout. I do want to identify that this is a very simple bill. I know we say with some tongue in cheek, but essentially it is because it already requires, the full pendency of an actual forfeiture proceeding. Remember what I spoke earlier about the asymmetry about contesting these hearings. There might be $500, $300 in question of whether or not it's contraband, but it would require attorney's fees of $500, $800, whatever the case might be, in excess of that. If you're a person not of means, what do you do in that case? It is, homo economicus dictates that you actually walk away from that. So you are basically being deprived your day in court because you don't have the means to put that in up front. Now, I also want to point out, because of some of the previous testimony, is that we hear that this doesn't happen, or our practice, our SOP is X, Y, and Z. And, as you know, we're not governed by, governed by angels. And the reason we put these guardrails in place is because our rights, our natural rights, do not arise simply from the beneficence of an agent of the state. And I think that's a very important thing to remember here. So when it comes to awarding attorney's fees on a failed forfeiture motion, I would also point out that it also, it talks about loser pays. The loser does pay. The loser's losing his property in the antithesis of that. So I think that has been substantially addressed, and I think that this bill would provide a good civil guardrail on that particular element.
Thank you very much. Quick question, because anytime we're considering new legislation, it's always important to consider, is a law like this needed? Is it your perspective, is it your position that absent a law that makes the emendations to the Texas Code that this one does, we could have the position where innocent people are in fact financially incentivized not to attempt to get their property back, even though they have in fact committed no crime and certainly not been adjudicated with guilt of the commission of a crime?
Absolutely. A simple economic analysis on the fact will say, look, this guy's going to charge me a $5,000, $8,000, $1,000 retainer up front. I'm short $300. There's no world in which that actually makes economic sense.
Thank you very much. Members, any other questions for the witness? Thank you for being here. Okay. Is there anyone else who wishes to testify on, for, or against HB 1874? If not, the chair would like to recognize Representative Noble back to close on her bill.
Thank you, Mr. Chairman. I am so glad that most of the time when there's a bad seizure, it goes back immediately to that person, to the party. And I think that this would be a very rare instance where someone needs to fight for their property. But when they do, and when it's appropriate, I think that they should not be upside down from dealing with the state of Texas and for those that represent us and in law enforcement and in the district attorney's office. So I think this is just a fair and simple bill that will address this situation, and I respectfully request passage.
Great. Thank you very much, Representative Noble. The committee substitute on HB 1874 is withdrawn, and if there is no objection, the bill will be left pending. Is there any objection? Hearing none, the chair leaves HB 1874 left pending. And at this time, I would like to ask Representative Schatzline to relocate with me.
All right. This time, the chair lays out HB 2992 and recognizes Representative Harrison to explain their bill.
Thank you very much, Mr. Chairman and members. While this committee is considering a wide range of potential reforms to the state's civil asset forfeiture process, this bill is a bill which simply adds greater transparency to the current system. It requires agencies to report to the Attorney General how they obtained forfeited proceeds and requires that this information is made easily available to the public through a searchable database. Under Chapter 59, law enforcement agencies are authorized to use Texas civil courts to sue and forfeit property, even in the absence of a criminal conviction or where there is no arrest of the property owner. HB 2992 implements reporting changes recommended by the House Committee on Criminal Justice Reform interim report and provides legislators with the information necessary to oversee the use of Chapter 59 civil forfeitures in Texas. The interim report submitted by the House Committee on Criminal Justice Reform in January of 2023 made several recommendations based on its study of the civil forfeiture process in Texas. Currently, agencies are required to report to the Attorney General how they spend forfeited proceeds, but there is no reporting requirement on how the agency obtained the forfeited proceeds. The interim committee found that, quote, the legislature should expand reporting requirements and require the tracking of county-level data on civil forfeitures. The report went on to say, and I quote, this information should be easily accessible and not require months of paperwork and public information requests to obtain. Finally, the report found that, and again I'm quoting, at the county level, we should know the basic information regarding any forfeiture, the location it occurred, the amounts and a description of the property, any criminal charges associated with the seizure and their outcome, as well as the final disposition of property. Specifically, this bill requires the Attorney General to create a case tracking system to collect and organize data regarding property seized or forfeited. The Attorney General already has similar systems in place for agencies to report how forfeited proceeds are spent. In response to the interim committee's recommendation, the bill then requires the agencies to report to the Attorney General specific information on proceeds forfeited, including what was seized, the value of the property, the underlying offense, whether any charges were filed in relation to the seizure, and the disposition of any charge. It also asks for the case number for the forfeiting proceeding, whether the property owner filed a claim to get the property back, and finally, what happened to the property in the end? In other words, was it returned? Was it sold? What was the final disposition of the asset? This is all information that the agency should already have easily and readily available, and most, if not all, is part of the pleadings for the forfeiture proceeding. Additionally, it is all available through Public Information Act request. However, as the interim committee recommended, the information should be much more easily available to the public. So to that end, the bill requires the Attorney General to make the data available on a searchable website. Finally, to prevent an undue burden on the agencies, the bill allows agencies to use forfeited proceeds to pay for any costs associated with this reporting requirement, if any arise. If this bill were to pass, Texas would become a model state, I believe, for the reporting of civil asset forfeiture. And with that, I will gladly take any questions from the committee members and respectfully reserve the right to close.
Members, is there any questions for Representative Harrison? Okay, if there are no further questions, we will proceed to testimony.
Thank you, Mr. Chairman.
The chair calls James Smith, representing San Antonio Police Department. Again, thank you so much for being here today, and yeah, you can, and thank you for your service. We really appreciate all that you do.
Third time's a charm getting out of the seat.
So we show you registered as James Smith on behalf of San Antonio Police Department, and you'll be testifying against, is that correct?
Yes.
Okay.
Yeah, once again, James Smith, representing San Antonio Police Department and myself, and we're opposing this bill. I get it right? Sure, okay. Once again, I'm coming from the premise of the seizure laws aren't broken. I know there may have been some interim studies done during the session, but I've yet to see where this is needed. As what I had handed you is what is annually done. It's an audit report that we have to give to the AG every year. Now, obviously, it's probably at the 30,000-foot level, but at any time, the AG or anybody wants to come to us and they want to get granular on a specific case, they can do that. And you're right, Representative, we do have that information. But what this bill is asking us to do is to put every piece of work product into this database that, once again, it's going to be a reasonable dollar amount that's going to have to come from the seizure funds. And I would never sign a paper on what reasonable is. We debate that in reasonableness and all types of laws up here in Texas. But the fact is that it would take me a full-time staffer on top of what I have right now, who is our accountant, to actually input that on in every single case, every piece of work product. Very granular. Everybody will open records, we get those knocked out quick if somebody has an issue. We'll do that. We have to. We have to. AG at any time, a legislator wants to look at our case. We will get that information to you. But to actually have to input every piece of work product is, to me, it's just another bureaucratic issue that we're going to have. It's another hurdle that we're going to have to go through, and it's going to make a lot of agencies. We could probably pull it off on ourselves, Houston, Dallas, but it's going to be very cumbersome. But for these small units to be able to do this, it's going to be almost impossible. And like I said, who knows what that would be? Hey, if the AG's willing to pay for it, maybe we can do that. But we know there'd be a fiscal note attached there, and it wouldn't go through. But I just want to reiterate once again, with all these seizure laws, this is a quality of life issue. It keeps our citizens safer here. Property rights, innocent people's property rights are protected. And I just want to make note, there's an anniversary coming up here in June 27th, something that took place in San Antonio. No one's going to remember it, but this is a cause of the drug cartel, everything that's going on. On June 27th of last year, that's when we lost 53 people inside of that tractor trailer who suffered in the heat and died. And I'm passionate. I'm passionate when it comes to these seizure laws because I know the good they do in this state. And there's been a lot of bills this session that are attacking this whole process, which I know works. It works. It's fair. It's fair to the taxpayers. It's fair to the innocent owners. It really does work. And I appreciate some of the other bills that have been out there where we might have enumerated offenses. We have issues with the street racing, with, like I said, the DWIs.
I apologize. I just want to clarify, we can only speak on this.
I know, I'm sorry. I went down the rabbit hole. I apologize.
No worries. And I share your concerns, especially when it comes to human trafficking. I completely understand. I guess I would have a question, and that would be, this bill really seeks to provide transparency. And, would you agree that we need more transparency in our systems to be able to show that we're doing our due diligence when it comes to these laws?
I'm 100% about transparency. Everything in our case jackets are transparent. What the DAs get are 100% transparent. But to ask us as one group out of the state of Texas to provide every piece of work product, you're not asking that for the homicide investigations. Hey, you need to put this into a database, and you have to have every piece of work product in that database just so people can see it. Anybody can see that. That's the idea of the open records. People can get it if they want. The AG can get into that anytime they want. We're an open book. We are an open book. But this is way too burdensome. As I said, I've repeated it probably 6 times. It's every piece of work product. And that's going to take away time from us actually filing the cases and getting these cases adjudicated. It's just very cumbersome. And to me, it's another roadblock to prevent us going forward with a great tool that we have in the state of Texas to keep people safe and secure.
Members, are there any questions for the witness?
Thank you.
Thank you so much for being here.
Thank you all again.
All right. Next, the chair calls Angela Beavers. We show you registered, thank you for being here today. We show you registered as Angela Beavers on behalf of Harris County DA's office, and you will be testifying for the bill. Is that correct?
Yes, it is.
Great.
Do I need to identify myself again?
Only if you want to.
You just did. Okay, great. Yes, I do. I welcome and support this bill. And thank you, Chairman Harrison. The more transparency that's available to the public, the better. The more transparency there is, the more that I feel it will dispel and discredit misinformation and false narratives about asset forfeiture. And it will get and shine light on the truth about how effective asset forfeiture is and actually how well it's working, and at the same time protecting due process and property rights. The only thing, and I think we've heard it, that I think most law enforcement agencies would be concerned about is the time and personnel resources. It will require to gather and report all the items in this bill. Maybe there can be further collaboration with law enforcement to maybe refine the list of data to alleviate some of those concerns. But as it stands, I'm for it. I love the searchable database. That's really easy for the public to use. I really like the part about whether when a federal law enforcement agency, in some of these HIDTA task groups, where there's a combination of state and federal agents that are working together, sometimes they have a choice to take it federal for federal asset forfeiture proceedings. I would love to see the data on that. A lot of times we're not privy to that. So anyway, we are for this bill, maybe with some tweaking to alleviate some of the use of resources that may not be there. But anyway, we are for that, and I'd be happy to answer any questions.
Members, are there any questions for the witness?
No, not so much a question. Thank you for being here. Thank you for your support of the bill. Just a comment that I'd be happy to have offline discussions if you have, constructive comments on ways to potentially improve the bill. But thank you for your support.
Okay, thank you.
Thank you so much.
Thank you, members.
All right, at this time, chair calls. I don't want to get this wrong, but I believe it's Akonska. I'm going to have you say it so I don't mess it up. Okay. And I show you registered on behalf of Texas Appleseed, and you are registered for the bill. And please state your name so I can.
Yes, Akanksha Balakai, thank you.
Yes, you got it.
Yes, and I'm testifying in favor of this bill, as you said. So hello, my name is Akanksha Balakai. I'm a criminal justice policy analyst with Texas Appleseed. So we're an organization that's dedicated to safe, data-driven, and efficient policies. I want to start by thanking the chair for bringing this bill and echoing how urgent and essential it is that there's improved transparency in our state civil asset forfeiture process. So this bill has two vital functions that have largely already been covered. It expands our state's reporting requirements when a stop that results in a seizure of property occurs, and it makes sure that all the information collected as a result is shared in a timely, accurate, and thorough manner. As it stands, there are very limited reporting requirements when a peace officer in our state seizes property during, for example, a routine traffic stop. And currently, law enforcement does not even necessarily have to report the initial alleged crime that might have led to that seizure. Beyond this, the information we are reporting and collecting is largely only being shared in aggregate. So even with that state audit report, from the Attorney General, there's not a lot of specificity within that. So we may have little to no idea of a lot of the details of these cases, and we also don't necessarily know whether these cases are ending up with a forfeiture by default or they're paired with any sort of conviction. So all this to say, there's been a lot of agreement that our state's asset forfeiture process is very ripe for reform, but a critical component of reforming it is first understanding how it's already operating. So we are not a direct service organization. Texas Appleseed is not, but we get calls about this issue frequently from folks who have had their property seized and are asking us about recouping it and what the process is. We ended up creating an asset forfeiture toolkit in response to that. So certainly there are a lot of different narratives about how asset forfeiture is working in our state, and what this bill does is it really gives us the best objective idea of how it is operating. By giving us that data, by making it so publicly accessible, that's how we can have a better idea of what those next steps need to look like. So I want to once again reiterate my support for this bill, and I'm happy to take any questions that there may be.
I just had one question. So you would argue then that, currently as is, it's very difficult for a citizen to even understand the process of how to find out, the transparency of what's going on with their assets.
Oh, absolutely. I would certainly agree with that. Whether or not they're just trying to understand what's going on with their own case or more generally understand how asset forfeiture is operating in our state, there's very little information out there for them.
Members, are there any questions for the witness? Thank you so much.
Thank you.
All right. The chair calls Derek Cohen. Thank you once again for being here today. We see you registered as Derek Cohen on behalf of Texas Public Policy Foundation, and you'll be testifying for the bill. Is that correct?
That is correct, and I will make it brief because I know you'll all be getting the bells here pretty soon. So just to, there's actually been a lot of good stuff entered into record already, specifically on the need for transparency and the fact that the only way this information is actually discernible under the current setup is either A, producing it in grand aggregate from the Attorney General's website, or having to go through an actual open records request. And I think that the advantage to this particular bill is again, it was mentioned in the context of narratives, but I think it really would help if there were transparency on the aggregate number of defaults, the number of things that would actually have to proceed to criminal trial. And I think that this bill would get at it. Again, we mentioned that, $34 million is what was forfeited this last calendar year. And we can't tell you how much. Was it 90? Was it 9%? How much was actually pursuant to a criminal charge? Further, I would also say that the elements that would be entered and reported, at most, this isn't, every single work product. This is 21 items per case maximum. And, I think we would also see the extended value of what these funds are paying for. It would actually show that. And I know in an open record request that I've done, that essentially some of the things that we've seen, these law enforcement expenses, are, again, $700,000 in laptop bags, $113,000 in office supplies, $151,000 in toner, $35,000 in paper. Now, look, I don't work for Dunder Mifflin, but I think that would actually be something that would, most jurisdictions would find eye-popping. 94,000 professional memberships, 64,000 in conferences, 170,000 in non-software subscriptions. All these things could have an arguable law enforcement purpose, but unless you actually go ahead and make that direct request of the agency for the expenditures from their Chapter 59 account, you never see any of that. And I think that this transparency would actually, again, bolster those agencies that are spending this on law enforcement expense, ask some questions about the ones that aren't, and we can move forward on good policymaking from there with that extra layer of transparency.
Fantastic. Members, are there any questions for the witness? Thank you so much. All right. Is there anyone else? Oh, excuse me. All right. At this time, the chair calls Arif Panju. Thank you for being here today. We show you registered on behalf of Institute for Justice, and you will be testifying for the bill. Is that correct?
Yes, I'm Arif Panju with the Institute for Justice, and we are for HB 2992. I'm not going to replow the field. There's a lot that's already been said. I 100% agree with Derek Cohn at TPPF that there's existing reporting on the spending. There's nothing on how the forfeiture statute is used, and it's not burdensome to enter a few data points when you're already writing the legal documents, you're writing discovery, you're writing affidavits, you're filing petitions. The information's right there. The login to the AG's office already exists. And so we're not reinventing the wheel with this bill. What it does do is something important. It does two things that helps the legislature and the people of Texas, since Chapter 59's power is wielded in the name of the people of the state of Texas. One, it allows the people of the state to see how forfeiture is actually used in the state, be able to learn about perhaps there's some aspects to the policy that need to be changed. Data helps that, and the data already exists, and this bill simply organizes it in a coherent, manageable way for the 21st century and allows it to be searched online. The second thing is that the legislature has the power of the purse. It's responsible ultimately for spending and funding our government and various aspects of the branches that exercise their powers. And so it's incumbent upon the legislature to have the means to be able to see how the power they confer is used. Sometimes you see it with sunrise reviews, or you see it when they review licensing boards. You see it in the budget. Numbers and data matter. And when you're dealing with civil court litigation taking place by members of prosecutors, which normally operate in criminal court, a House committee, bipartisan, issued a correct study committee report that concludes that there is a huge gap in information for even the lawmakers. This fits the gap with something meaningful and something not burdensome, and allows the agencies to use forfeiture funds if they have forfeitures to report. We're in support of the bill. Happy to answer any questions. I'm also happy to see that the DA in Harris County is supporting a transparency measure. I think that's important, and so we appreciate seeing that as well.
I agree. Thank you so much. Members, are there any questions for the witness? All right. Thank you. All right. Is there anyone else who wishes to testify on, for, or against HB 2992? If not, the chair recognizes Representative Harrison to close on the bill.
Thank you again very much. And if I do say so, fantastic job, Mr. Chairman. Thank you very much. I would appreciate the committee's favorable consideration and, if possible, a speedy reporting to the floor. Thank you.
Thank you, Representative Harrison. If there is no objection, the bill will be left pending. Seeing none, the chair hears none, and HB 2992 is left pending. I now yield the floor to Chairman Harrison. Yes, sir.
That was the last one. That was it, okay. Okay, members, that concludes today's agenda. If there's any further business for the committee to address, hearing none, the chair moves to adjourn. Is there any objection? All right, hearing none, the committee stands adjourned at 9:49 a.m., subject to the call of the chair. Thank you very much for being here today.